Hello everyone and welcome to today's King's Expert Series, Privacy in the Age of COVID-19. This webinar is part of our brand new online series exclusively for members of our global alumni community. Each month you'll have the opportunity to tune in and hear from some of our leading academics, researchers and practitioners on some of the most pressing issues of our time. If you missed any of our recent webinars, you can catch up at any time on the King's Alumni YouTube channel. Despite not being able to hold in-person events for you at the moment, we have a great schedule of online events coming up, including an event with our careers team on navigating the current job market on October 15th, and another one of our ever popular alumni versus students pub quizzes coming up on the 22nd. Do keep an eye on the website for more details. So today you'll be hearing from some of our law school academics on their perspectives on personal rights and privacy in relation to the current public health crisis. I'm sure you've read their bios, but just briefly to introduce our speakers, we have Mr. Perry Keller, who is a reader in Media and Information Law at the Dixon Poon School of Law here at King's. Professor Roger Brownsword is a professor of law and the founding director of the Centre for Technology Ethics and Law in Society at King's. Our chair for today's webinar is Dr. Emily Hudson, also a reader in law, as well as director of the undergraduate studies and chair of assessments at King's. Just a quick word about the format of the discussion before I hand over to Emily. Following an opening discussion from our panel, we'll then turn to your questions. If you have a question at any point during the discussion, you can use the Q&A feature at the bottom of your screen. Please be aware that since we do have a lot of you on the call today, we may not be able to answer all of your questions. Another way to participate is by clicking the like button next to someone else's question that you'd like to hear answered. I'll now hand over to our chair for today's panel, Dr. Emily Hudson.
Thank you very much. I'm assuming I'm about to be live or am live. Welcome to tonight's session in relation to privacy in the age of COVID-19. As Marika said, my name is Dr. Emily Hudson and I'm a reader in law. My research relates largely to intellectual property law, and so tonight I'm very excited to learn more about privacy law, data protection, and human rights from my colleagues Perry Keller and Roger Brownsword. There are numerous possible dimensions to our discussion tonight. So when we're thinking about the privacy implications of COVID, we might think, for instance, about the personal data that is collected when we visit hospitality and other establishments, and that's being recorded by track and trace apps. We might also think about the employment context. So whether we are asked to divulge private information to our employers, for instance, in relation to the need to work from home or to be provided with particular accommodations. Then there are still other broader privacy implications. So for instance, should a vaccine be available? There are actually privacy questions around bodily integrity and whether one could refuse to have a vaccine or indeed be required to have a vaccine. So there's lots of different dimensions to our discussion. And I think what we'll see tonight as well is how the pandemic illustrates broader issues in relation to human rights. So what we have often in human rights law is issues with balancing of different rights or of considering collective needs and individual rights. And so we'll see this in particular with our first panelist, Roger Brownsword, who's going to introduce us to this sort of bigger picture in relation to tonight's discussion. And then we'll turn to Perry Keller, who will talk in more detail about privacy and data protection and so forth. After they've given their prepared remarks, we'll then have our question time, which will be moderated by me. So it's now my delight to turn to our first speaker, which is Roger Brownsword.
Well, thanks very much, Emily, and good evening, everyone. Yeah, I'm going to talk about the bigger picture, so it's quite sketchy. But my starting point anyway is how we can justify the various restrictions or requirements that are being put in place all around the world in response to the COVID-19 pandemic. There are two areas in particular of concern. One area is the economy, which I think has been the dominant concern, certainly in the UK. And the other area of concern is about the impingement on our fundamental rights and freedoms, which in the light of the Prime Minister's remarks this week has, I think, become much more of a prominent issue. So it's how can governments justify their particular requirements and restrictions in the name of public health relative to, on the one hand, the economy, and on the other, our fundamental rights and freedoms. Well, as I say, I think the economic argument has been pretty well rehearsed. And my sense here is that there's a fair amount of agreement about what's at stake. And there's a very difficult kind of situation for any government to deal with, because if I can talk in terms of a hydraulic model, a lot of people seem to think that if you, the more you do for public health, the worse that is for the economy. And the more you relax restrictions for the sake of the economy, the worse that's going to be for public health. So wherever you pitch your position as a government, there are always going to be people who are discontent with a particular position that you struck. Now, I'm not sure that that hydraulic model is actually correct, but I'll leave that to people who are worried about that debate, because that's not our concern tonight. This isn't where issues about privacy and data protection are located. Rather, it's in the other area of concern, our fundamental freedoms and rights, that we find concerns about impingement on privacy and impingement on data protection. Or again, broadly understood in the way that Emily drew attention to when she was talking about vaccines. I mean, even there might be a substantial number of people who resist the idea that government should require submission to a vaccine. A recent survey in America suggested quite a large percentage of people there would not want to be vaccinated. Nevertheless, I do welcome attention in relation to this other area of concern, privacy, data protection, fundamental freedoms, and so on. But I don't think that there has been clarity about the nature of the debate here. When we talk about balancing, we say, well, we have public health on one side, and we have privacy or data protection or personal freedom or freedom of movement, freedom of association on the other. It's not entirely clear how that balance is going to be negotiated. And certainly earlier in this year, I felt that where people did raise privacy concerns, particularly about the new app, which of course has been launched today, but the earlier incarnation of that, I thought government ministers were a bit quick in responding to that. I didn't think it was enough to be saying, as of course people said very frequently, oh, well, this is unprecedented, the pandemic is unprecedented. So that's a blank check for doing whatever you like. Or again, it won't do to say, as it was said in relation to the earlier version of the new app, but you have a civic duty to comply, to cooperate. Yeah, I mean, we might, but those who are arguing from a privacy or fundamental freedoms perspective will want to say, yeah, but look, governments have duties too. That's the whole point when we say we have various kinds of human rights. What we're saying is you in government have a duty, or you public bodies have a duty to respect those rights. So even if we allow the switching the currency of debate from rights to duties, maybe we allow we can do that, we still end up with a conflict between duties, and it's not clear which takes priority. So as I say, I do welcome that we are giving attention now to the question of our fundamental rights and freedom. Now, the question for me is, say, about the nature of this engagement. And let me put it in terms of what would be the best kind of justification or the right way for governments to try to justify their measures in the name of public health, bearing in mind that on the other side, we have claims to fundamental rights and freedom. So the first kind of argument a government might put is that this is in line with the popular will, or there are an awful lot of people who would prefer us to be doing the kind of things that we are doing with public health. So the restrictions really ought to be in place. That's the right thing to do. But if a government relies on simple preferences, even of large numbers of people, although in ordinary circumstances, that might be a good argument. Where on the other side, people are pleading that they have fundamental rights or freedoms at stake, then, as the philosopher Ronald Dworkin said many years ago, in a community where rights are taken seriously and regarded as akin to trumps in a game of cards, then those arguments of rights and fundamental freedoms take priority over simple preferences, even though it may be the majority have those particular preferences or mere interests, as it were. Rights are a stronger kind of argument. They just take priority. So if we're recognizing privacy or data protection as a fundamental right, and in Europe there's plenty of legal support for that sort of view, then that argument won't do. So governments have to do better than that. And a better justification might be to say that public health or the public interest is some kind of proxy for other kinds of rights which are fundamental and which are now in competition with the rights to privacy and so on. Well, that's a possibility, but that's not usually the way it would be played. And I don't think that's the best argument either. I think there is a better argument than either of the two I've just indicated. And this is that governments has to say that the measures they're taking, the restrictions and the requirements, are necessary in order to restore a critical infrastructure for public health. You can't repair critical infrastructures without some inconvenience, without some impingement on freedom of action or freedom of movement or freedom of information, or whatever it might be. The other day, I drove from the south of England right up to the north of England, where I am now, covering 250 miles or so, mainly on motorways. There were an awful lot of roadworks on the way. They cause a lot of inconvenience. I could not drive in the way that I normally would when there are not roadworks on the motorway. Roads are one example of a particular kind of infrastructure. We use them generically for all sorts of reasons, but when they need to be repaired. If we don't have those maintained and repaired, then we can't enjoy the freedoms that we're pleading in the first place. So for me, the best kind of justification for a government is to show precisely how the measures they're taking are necessary relative to the maintenance or protection of a fundamental infrastructure. And that argument for me would be then kind of like a joker in a pack of cards. It would outrank even the Trump's argument, or if you like, they're super Trumps. You know, we're taking the argument to another level altogether. And we don't hear this very often because we generally, I think, collectively, are quite insouciant really about infrastructure. We just take them for granted. Infrastructures are incredibly valuable. We don't realize how valuable they are until they go down. And I'm keeping my fingers crossed that the critical IT infrastructure won't be going down in the course of this particular discussion today. Otherwise, we'll see just how important that infrastructure is. And if we have to go offline for a couple of minutes while someone puts that infrastructure back in place, well, okay, that's not great, but it's an inconvenience we have to put up with. So I would leave you with the thought that there may be an argument for these restrictions requirements, which hasn't been properly articulated yet, which is going to take us back to infrastructural conditions for our communities. And actually the sting in the tail there is that privacy, which means many things to many people, itself can be articulated in a way which takes us back to infrastructural conditions too, which leaves us then with some difficult choices about which bits of the infrastructure we're going to prioritize. But I think that that's the shape of the argument. And I'm going to hand over to my colleague Perry right now to talk more about the human rights, data protection and privacy nitty-gritty.
Thank you, Roger. Well, good evening. So what I'd like to do in this brief introduction is take some of the general issues that Roger was talking about and put them within the framework of data protection law. So one of the things about data protection law, of course, which we're also familiar with, at least in its impact, if it's not its details, is that it is now ubiquitous throughout every kind of service and activity in society, whether governmental and commercial, and that is its intention. It's meant to be a highly flexible mechanism to ensure that individuals have a maximum amount of personal information autonomy, whilst also allowing legitimate uses and flow of personal data. So it's a mechanism to adjust and work out how those conflicting interests are going to be resolved. And so it's very much at issue in relation to coronavirus and the government's response. So I want to take you in a little bit further into how this is developing. But the first thing I'd say after that introduction is that for some critics, they see data protection law as too much involved in enabling the datafication of our society and the development of this enormous transformation, which some have called the transformation to informational capitalism. The data protection law is serving incrementally to change the nature of society, and its protections are only secondary, and they inch along and follow the general flow towards a society in which monitoring and various kinds of interactive uses of our data becomes more and more ubiquitous. So one of the things we need to think about, or it's interesting to think about in relation to the COVID crisis and data protection, is to say, is data protection law serving its purpose of protecting our fundamental values through this crisis, so that we're going to emerge and feel that our values in it are intact, and even if society has changed in certain ways, we'll feel comfortable with the changes because our values are reflected in the practices that then exist? Or will we feel that we've entered into a different kind of society in which we're under greater surveillance in different ways, and that something fundamental has been lost in relation to our deepest values? In that sense, the COVID crisis is a stress test for data protection law, and we will have to see how that goes. So what I'd like to do now is to talk to you a little bit more about the mechanics of data protection law and where some of the stress points are. So as we all know, the UK in transposing and implementing the EU General Data Protection Regulations, the GDPR, into UK law, enacted the Data Protection Act of 2018. And within that, it has the basis for implementing the GDPR and also its companion law enforcement directive for law enforcement actions in relation to data protection, as well as some elements not covered by EU law, such as national security and investigatory powers. So the points I'd like to move through with you are, first of all, to say, well, if our personal data is going to be used for various reasons related to public health and COVID, whether it's in employment or in other locations where our personal data is taken, or in relation to health treatment, all of these stem down to the basic principle that our personal data can't be used without a lawful basis. And that, of course, very often involves consent. But in these circumstances, consent is a minor, although interesting factor, it might come in as a supplementary role. But the key issue here, the principle, is necessity. So can the government or some other entity charged with legal responsibilities, indeed one's employer, in relation to public health, rely on necessity under the GDPR and therefore within the UK Act to process our personal data? And this is highly important and sensitive personal data, known as special category personal data, because it concerns our health. So the safeguards that data protection law offer, or the general principles, and also rather familiar to people, of purpose limitation, that the data can only be used for limited purposes, that, and those purposes have to be informed to the individual whose data is going to be used. There's data minimization, only using it as necessary for those purposes. It should only be stored so long as necessary. Again, storage limitation, and also security issues, the integrity and confidentiality principles. So that's the basic package of principles which offer the potential to limit the scope of how our data is being used in the COVID crisis. The other key point to throw in, of course, is all of this is geared to European fundamental rights law through the EU Charter at the moment, and then to the European Convention on Human Rights underlying that. So that when we think about how particular safeguards ought to operate, we have to bear in mind the familiar principles of necessity and proportionality that are the key to the European model of fundamental rights. Roger mentioned earlier the idea of trumps, of rights as trumps, which relates to the more categorical model used by the Americans. And in this long-running and very critically important debate about how our society is developing, we'll be often thinking about, and we need to think about, other models of rights, because we're in one in which we can balance one right and another interest against them to come to what we think is the most proportionate way of preserving a right, but allowing other interests or rights to prevail. And the criticism there, of course, is that may lead to a certain amount of whittling away of rights. Now, just to bring my introduction to a close then, the key issues then about whether data protection law is going to provide these kind of this critical device which is going to help us through this crisis and with our values intact. There are two really big avenues, and one is it'll be through individuals exercising their rights and seeking remedies. That's clearly highly problematic because individuals are so often overwhelmed by the amount of information they're dealing with and the complexity of these. And so the key point here to think about is the way in which certain organizations have become phenomenally important in pursuing representative actions, and their ability to do so is, for example, under scrutiny and argument in the Supreme Court in the Lloyd versus Google case. So many people would say that the individual rights and remedies avenue is bound to fail in getting us through this. And what's really important is regulatory oversight, with the ICO leading that. And here, the ICO has really been heavily involved in, for example, the development of the new COVID contact tracing app, which has been put into operation today. And the ICO has insisted on data protection impact assessments and has had a very close dialogue with the developers, leading to many modifications in the app to protect our personal information autonomy, our privacy. But the thing I'd leave you with there is that this has taken an enormous amount of resource from the ICO on just that one project. And it's open to question that even that more effective regulatory oversight is simply limited by the resources of the regulator. There are many other issues I'm sure they're occurring to you now, and I'd be very happy to join Roger in taking questions.
Thank you very much, Perry. I might just start with a couple of questions. We've had some questions coming in the Q&A, and I've also got a few questions. And the first one I'm going to address to Roger, please. And I was just wondering, you were talking in your presentation about infrastructure, and the NHS came to mind to me. Is that what you're talking about? Perhaps you could elaborate on what you think might be the relevant infrastructures for the purposes of COVID.
Yeah, thanks, Emily. Good question. How do we differentiate between infrastructures and whatever activities take place on infrastructures? And I mean, like many distinctions that have some attraction initially, they become more complex as we move into areas that are more borderline. So I'm thinking that, you know, in the public health field, there's a lot of emphasis on the importance of basic infrastructures being in place for public health. So you're thinking about clean water, about shelter, about food, about basic provisions for human needs. I don't think this presupposes something like the NHS, as elaborate as the NHS, but some basic medical support, but it's pretty minimal. And for me, different communities will have elaborated their basic public health structures in different ways, so that at any point in time, what you would include within that particular infrastructure will vary from what in another community would seem to be part of their infrastructure. But the crucial thing is that the infrastructural conditions are neutral between humans, that they're not geared or designed for any particular human or group, but that they are intended to be for everyone's benefit, and that we all rely on. We all rely on them. Where public health, I think, starts running into trouble is when its advocates move beyond what clearly is part of the infrastructure and start wanting either to advance a particular conception of a healthy person, or well, get into dictating or channeling or nudging persons towards what public health advocates regard as being healthy lifestyles. So, I mean, and once you start moving into this area, and of course, a lot of prevalent diseases are lifestyle diseases rather than, I mean, COVID is unusual in the sense that, you know, it's highly infectious, but a lot of our diseases are lifestyle diseases, and public health proponents will often want to try to not just put in place the conditions for healthy societies, to give them a fair chance of being healthy populations, but actually achieve healthy outcomes. You know, so we have, you know, public health programs designed to deal with obesity, to discourage or prohibit smoking in certain places. You know, so that, I mean, some years ago, I was in a seminar where we were discussing New York City's public health program, and the mayor of New York was very keen on things like people not being permitted to smoke in public parks. Now, if you start taking public health to that extent, you are going to run into these rights which we're elaborating in the name of, you know, fundamental freedoms and rights. So this is where you pitch into those. And so, yeah, by all means, in the UK, the NHS is certainly part of our infrastructure. Yeah, I mean, I don't know whether there are more, I mean, there are more difficult cases like, well, putting fluoride in the water supply. I mean, that was once upon a time a huge bone of contention. Would you say that was infrastructural, or is that going beyond it? I mean, that's one of those questions that, you know, lawyers could argue all day about, sort of thing. But it's like a lot of these sort of public-private, you know, infrastructure, superstructure. Where exactly the infrastructure ends and the superstructure begin, I don't know. But I mean, my point, I think, is that if you're trying to justify some action on the grounds that it's about maintaining or repairing an infrastructure, the set of conditions you're trying to defend have to be neutral between humans as persons, humans with particular projects. It's not for a particular group. It's not partisan in any way.
So, I mean, I guess as you were sort of talking, then I was thinking about, in terms of during the pandemic, we've heard of issues with hospitals not having enough oxygen, in terms of having to, that once upon a time oxygen just came out of the walls and it was okay for ventilating patients, but during COVID, with so many patients requiring ventilation, in actual fact, suddenly how do you get enough oxygen around the hospital becoming a major issue? With that is, when you talk about infrastructure, I mean, that's a quite literal, like physical building infrastructure. Is that the sort of, might that be one thing? Number of ventilators, PPE, is that to sort of, I'm just sort of wanting to just get a sense of how you use roads as the example. How much are we talking about buildings and physical kit, and how and as opposed to sort of other things?
Yeah, well, in communities like the UK, where we do build buildings and where we invest in these sort of, I mean, when in the 21st century, the infrastructure looks a bit different to how it might have looked in the Victorian years or earlier. So, I mean, I think we're talking about an environment that is at least conducive to public health. And some natural environments will be more conducive than others, you know. And having COVID-19 circulating around is not conducive to public health, and we have to try to do something to mitigate it. But we don't, you know, our community has reached a stage of its evolution where we don't rest content with whatever natural advantages we might happen to have in having a healthy environment. You know, the climate here is reasonably favourable. But we don't rest with that. We try and enhance the environment for public health. And hospitals and oxygen are part of that enhancement. I'm not sure, Emily, I can go much further than that.
That's fantastic. I just really wanted to elaborate on the infrastructure point and get my mind around it. I've got a couple of questions now for Perry, if we might. So one question which has come in on the Q&A was also something I had been thinking about was the data protection law post-Brexit. So just whether you had any sense or inklings as to whether or not you think at the expiry of the withdrawal period, is the government going to make any major changes to data protection law to sort of take it away from the GDPR, or do you think that the sort of nuts and bolts will remain fairly similar, at least for the sort of foreseeable future?
Thanks, Emily. Well, I first of all say if I knew the precise answer to that, I would be planning to be a very rich man. But I'll take it apart and see what I can do with it. Is that the intention that has been expressed by like Mrs. May's government in the past, and to some extent by Mr. Johnson's government, is that the UK intends to maintain the same standards as the EU in relation to data protection. And that's essential if, as part of a new agreement on trade, that would include what would be called an adequacy agreement. And that would mean that we could treat the flows of data between the EU and the UK as if they were simply essentially within the same jurisdiction. There's been some murmurs as part of the rather more turbulent discussions of what the future might be over the last few months, but maybe we won't maintain an EU-style data protection regime, which some people think is too onerous, as it's it could be said to be underdeveloped where it's most important, but it is overly burdensome in many areas where the data protection risks are quite small. So maybe we would depart from that, but that would have a huge impact on data flows between the UK and the EU. I'll just throw in that all of this is under the shadow of the Schrems II decision in July, which was in relation to data flows from Europe to the United States, but it has enormous implications for us in the UK as to whether our national security surveillance is contrary to EU law. I won't go into the rather complex doctrinal issues why it hasn't been an issue before, but as a third country to the EU, it will be an issue. And we may find out that even if we have an adequacy agreement with the EU, it will be challenged and declared to be invalid by the European Court of Justice. So.
Thank you. Thank you very much for that. I might keep you also for the next question. At least at first instance. So this came in on the chat and it's quite a nice one. And if it's okay, I might just read it out in full. It seems as though we are currently faced with the seemingly impossible choice between civil liberties and freedoms on the one hand and the protection of human life on the other. governments across the world have implemented policies which lean towards the latter, but at what point do we recognize that the line has been crossed, i.e. how do we recognize that we have gone too far? So thank you for that question. Perry, do you have any thoughts on that? How do we recognize that we have gone too far? So this is just to be clear about the choice between civil liberties on the one hand. Oh, sorry, it's just moved. Civil liberties and freedoms on the one hand, protection of human life on the other. We've been protecting human life, but at what point do we say we've gone too far? I guess then in sacrificing civil liberties and freedoms.
Okay, well, if we use data protection law to look at that problem, you know, the data protection law is the first response would be that it isn't a set line. It's a mechanism to come to conclusions as events evolve. And so one of the key issues is, for example, purpose limitation, data minimization, as I mentioned earlier. So we can say some of the government's early ideas about the contact tracing app would be it would be centralized. So all the data would be held by a central body. And so we'd be able to, although the data would be held in a very secure way, nonetheless, a central body would be able to identify when somebody somewhere in the UK, or at least in England, had been exposed for a dangerous period of time to another individual who had tested positive or was in fact ill with COVID. So what has emerged out of that is the contact tracing app, which is coming into effect today, and that's decentralized. A lot of it, the data is simply held on one's own phone, and there is no, a central authority cannot know the identity of individuals who have been exposed. So we can see that's a way in which data protection law was an important force through, as I mentioned earlier, the work of the ICO to say that the government's way of addressing this, it might be more effective to have it centralized. I mean, that's the way it's, for example, it's done in China, but that was unnecessary to have that centralization, that one could get a similar, maybe even a somewhat less effective contact tracing system, but without that centralized knowledge about geolocation of everybody who had the app. Mm. So, but I just add in one other point. So we have an ability as we go through it to use these tools to say, what is the proportionate way of balancing the conflicts and come to these moving conclusions, because after all, we could find out this decentralized app just doesn't work very well, that people who get the information and they're told they ought to self-isolate are simply not doing it. And there's no way to track them down, and we may come back to a centralized system. But the thing I'd leave you with then is to say a lot of this it's like we're under pressure, coming back to Roger's point about we're trying to preserve this essential infrastructure, and we're bending and pushing away from the norms we know, the practices we know. And a very key question is, will we move back afterwards? Or will we find that we've reset the balance between our personal liberties and our relationship with the state and our relationship with our employers and others? And coming back to the question, you know, then you could say, well, we crossed a line and we've never recovered from it.
Perry, I'd like to come back to that final point, but before we do, I wonder, Roger, if you want to come in to also answer this question in relation to whether or not, well, how do we recognize that we've gone too far? So you've got your sort of, you mentioned these sort of justifications by reference to infrastructure. Just if you could want to say anything further about actually then how that sort of plays out in practice.
Yeah, thanks. Well, I'll keep this short. I think there's a difference here between the question of principle and the question of practice. So if we're talking about how high do we value the right to life in principle, the answer is going to be very high indeed. There might be some communities that say place human dignity as a top value, but I mean most human rights supporting communities will have the right to life ranking very high in the order of rights. But of course, there are then questions about, in principle, what is the scope of the right to life? I mean, how much positive support for life does this require? I mean, we're not just talking about people being killed, we're talking about letting people die. And, you know, there is an argument that oldies like I should just be allowed to take our chance, and we shouldn't be, you know, putting huge public resource into keeping us alive. So I think that's quite problematic in principle, but in practice, I mean, the question of how do you know whether you've gone too far with this or whether it's working, well, that, you know, that like all practical questions is very difficult indeed sometimes to answer. So I'm not quite sure how to frame. I mean, there certainly is a good question here. I'm not quite sure how to frame the way we engage with it, actually.
There was a question that came through ahead of time by email, and it relates to surveillance capitalism, by Shoshana Zuboff, and a correspondent asking if we were aware of that book and the data accumulation by Google and Facebook and so forth. And that question also ties into something which I was thinking about when I was listening to both presentations. That it's interesting that people object to putting a COVID app on their phone, and yet they turn on Google locate services and can find out to the meter where they were for the past X many years of their life, and have all manner of data being collected. And I was just wondering for both of you whether you have a sense of what's going on here. Is it that people don't fully understand and they just accept things on the basis that whatever, it's not really important that some entity is recording this data? Do you have any sense of that? Because you could say that there is a sort of, that it is strange that a COVID app people say no to, but Google and Facebook, and it's like all bets are off. Roger, do you want to start? And I'd like to hear from both of you, but Roger, you're on screen, so if you, at least at my end. Okay. So happy to start with you.
Well, thanks, Emily. Again, I'll keep this short because I know Perry and I have talked about Zuboff's book briefly before, but it's of course, we're talking here about, for me, a threat to an infrastructure for individual or agency and autonomy, presented not by a government that is not doing the right thing by our infrastructures, by public, but by private interests, and also introducing, of course, an international, global dimension to this, cross-border dimension. It's not, we're not fully in control of of these challenges. So, the problem with surveillance capitalism, as Zuboff puts it, I think comes in two stages. The first stage seems relatively innocent, or it's difficult for us to put our finger on why we really have concerns about it. But the first stage is simply through big data, these tech companies are able to profile us in a way that gets a clear steer on, which films, which books, which restaurants we like, and which recommendations might stick with us and persuade us to go out and spend money. So it's kind of sophisticated marketing that we're talking about. And we buy into it because we, as consumers, we buy. And a lot of the things that are recommended to us on Netflix or whatever, we think, oh yeah, right, that I might like that. So what's not to like about that? Why are you getting so agitated about this? And Zuboff is, well, I mean, there are reasons to be agitated about that, I think, but it's as the profiling moves away from online environments into the offline world as well. And our, conversations with Alexa or whoever are again gathering data all the time about our preferences, our likes and dislikes. And Zuboff's saying that in the second stage, the agenda of the big tech companies is to not just to anticipate what we might like or don't like, or what we might buy or might not buy, but actually to control our preferences. Now, this becomes quite dystopian. And she talks about a book by B.F. Skinner from the 1970s called Walden 2, which I always loved this book, but I was never sure whether the model community there was dystopian or utopian. But, you know, I take it to be dystopian because although it's extremely conformist, well, people in the community are very conformist and outwardly respectful, they're not really in control. They don't really make their own choices anymore. And their choice are being controlled by others. And so in this insidious way, the environment for us being autonomous agents, I mean, I don't know whether we really do have free will, but we like to think we do, is that environment is being compromised by the collection of data, and then our reliance on devices which prompt us all the time to act in a particular kind of way. So, you know, we're being nudged and channeled all the time in a way that eventually will take away our own, I think, our own capacity to be in control of our own lives. So for me, that is a deep, I mean, that's a future foretold that might not actualize, but yeah, I mean, that again is something that goes right back to the infrastructure. And if we say, hang on a minute, this is a problem in relation to our privacy, and privacy is about an infrastructure in which we can be ourselves, you know, develop our own interests, have a sense of ourselves, be the person we want to be, you know, then this is a deeply troubling development.
Perry, do you want to also jump in with anything?
Sure. Thanks, Emily, and thanks, Roger. Let me unpack this as quickly as I can. The first thing is to say that the whole COVID crisis has overtaken something else which was brewing and developing in the area of data protection enforcement, and that was investigations into this area, which is known as ad tech or programmatic advertising, and beginning to strip away and put pressure on some of the companies that are key to that kind of personalization and commercial surveillance of how we do things online. And but nonetheless, the COVID crisis has overtaken the regulator like the ICO, and it's had to pause its work in that area, although I'm going to be working in that area on programmatic advertising with the ICO over the next year to looking into that. So that's to say that we're all distracted by COVID and its implications for personal privacy, but these other things are still there, and they're enormous, and they're developing while we're being distracted by COVID. In relation to Shoshana Zuboff's work, which is very interesting, I find Julie Cohen's work, and her book, Between Truth and Power, came out about the same time. And she differs from Zuboff, and where Zuboff talks about a kind of lawlessness that's going on, I think Cohen is more convincing to me that she says, this isn't lawless at all. This is part of the legal underpinnings of this great transformation. She would say it's the second great transformation of human society. The first was the Industrial Revolution, and now we have this transformation from industrial capitalism to informational capitalism, and law is essential to doing the work of making that possible. And I think that's a really interesting and important insight. And she would say, so what we need to be looking at are the ways that we develop new tools to ensure, as I said before, that our values survive intact in a way that we recognize and we find not only are there at an abstract level, but in the experience of life, tying in with what Roger said. So that leads me to one of Julie Cohen's criticisms I think is really relevant here is a lot of this traditionally is underpinned by the idea of individual rights and our ability to exercise individual rights. And I think, as I said earlier, in relation to things like ad tech, programmatic advertising, the ways in which we have this kind of overwhelming surveillance of ourselves in different ways is that the individual rights model is still interesting and potentially able to strike some important changes in law, but for the most part, consent is the door to more surveillance. I'm sure everyone today has consented to something that came up on their screen and they didn't really know what it was about, but they were too busy, rushed to stop and question whether it was what they wanted. So we give away our data autonomy through consent very often. We all know that. So this is the question then is, how do we find new ways of addressing this? Because the individual rights, the kind of notice and consent model is plainly taking us down the river.
That's fantastic, thank you. And Perry, I'm going to stay with you because I'd like to, we've got a few minutes remaining, so this might be the final topic. We'll see how we go, but wanted just to talk about the employment context. So one question relates to information that you might need to, well, might be asked to divulge to an employer in relation to COVID, whether it be whether you can be allowed to continue to work from home, or when people are being required to come in the recent times, it may be that at least for some white collar workers, this has changed a bit with the government's revising its position on us all returning to work and saying, no, please work from home where possible. But certainly in this sector, it's an issue at the moment in terms of university staff going back for face-to-face teaching. So what sort of, when we're having discussions with our employers, whether or not there might be information that is being requested, but also then information between staff. There was actually on the thread, an anonymous attendee said, you mentioned vaccination. I work for the NHS and we are being put under pressure to have the flu vaccine. And there is a certain amount of naming and shaming going on. What is the protection here? And what that comment made me think about was also that there's not just that aspect vertically between an employer and the employee, but also perhaps that when one, for instance, if you are walking around without a mask and you're challenged, do you then need to divulge certain information to the person challenging you, a colleague, or indeed just perhaps somebody on the street? So I just wonder if you had any thoughts about the employment context in relation to any of the matters I've just mentioned, sort of disclosure of information upwards or between staff.
Okay, yes, Emily, I mean, that's brilliant because it's something everyone can relate to and has different experience of, and to see this is where data protection law, hits the road, and we see the friction in it. And in principle, we say, well, this is taking us into a really new area in which our employer suddenly is asking for very intimate health information about us. It's not just COVID, but comorbidities that we might have, and we're being asked to disclose that to our employer, and data protection law allows that under a necessity provision relating to the legal obligations of employers and other elements as well of data protection law, but that being a key one. So in that we can say, okay, well then the principles come into the force, this has to be done in a transparent way. We have to be informed. There has to be a purpose limitation, data minimization, etc., as I said before. So we can say that it should only be done where entirely it can be justified as necessary, and all the measures have to be proportionate and, of course, temporary. But then there are so many workplaces, and that thrusts us back onto, the ICO is doing an interesting job in relation to contact tracing apps and other things, but at the same time cannot possibly be everywhere. And then it's down to individuals who might feel that because in these economic circumstances they want to continue in employment, they'd better bite their tongue, or except they better not bite their tongue, and they better give that information their employer is seeking, even though they do feel that it is unnecessary, and that it's this, as you commented, that one of the questions said about naming and shaming, which would be contrary to data protection law, but who is going to do something about that?
Thank you very much for that, Perry. We're in the final couple of minutes, and I thought, just to conclude for both the panelists, what I might invite you to do is to give a final thought, if there's anything you haven't said yet, anything that comes to mind from the discussion that you want to speak to, any final thoughts, predictions, to say them now. We also did have a question which I can also put to you, if which was this was again from the Q&A. Could we say the GDPR is getting in the way, I should say, of solving this crisis? So a final thought or response to that question. Roger, I might start with you actually, if you want to just leave us with a final remark.
Oh, thanks, Emily. Yeah, I really just wanted to pick up on something that Perry said a long time ago about privacy and data protection, because I haven't said much about either privacy or data protection. For me, the attraction of privacy is that if someone asks me for information that I and the law regards as private, I can just say no. It's not your business. An employer says, I would like to know about your circumstances in relation to, and it's treated as private, as a matter of privacy, then I can just say no. And someone say, well, that's unreasonable. Well, I don't have to say anything more, really. I mean, it's like property, Emily. I think if it's mine, it's mine. And if it's private, it's private. And if I said to someone, treat this as confidential, then again, that is restricting, so we have sharp, clear entitlements in that case. When we, as Perry said, go over to data protection, although data protection was anchored to the idea of privacy historically, not so much, I think, in the GDPR, but the truth is that data protection's got little or nothing to do with privacy. I mean, it's not about data subjects really being able to say no. It's about whether those who are collecting and processing data have a legitimate interest or a reasonable, or it's in line with reasonable practice in the area. It's about data flowing. It's about transparency and proportionality and all sorts of other things. And it's Byzantine. I mean, I'm not sure whether the GDPR is getting in the way of doing the things that we should be doing, but for sure, anybody who gets into the GDPR is immediately lost in what I'd regard as a maze of legal provisions, which are full of difficult points of interpretation. I mean, the GDPR is for GDPR specialists, not for ordinary lay non-lawyers, or even for non-information lawyers. It's just so privacy has some attractions in terms of being sharp and clear as to I can just say no.
Fantastic final observation. Thank you, Roger. Perry, do you have a final observation?
Well, I do think that GDPR has had an impact. If it hadn't been for the GDPR and the UK's model way of pursuing it, we would probably be having a centralized contact tracing app being rolled out. I mean, there are technical reasons, obviously, why they ran into problems with that, etc. But the GDPR was a big reason why not. So it is having an impact, and a centralized one would be more effective. But I think, and I would leave it with you, is that, China is doing this more effectively because the state in China, the party state, is not burdened with those kind of data protection restrictions. They apply to some extent to companies in China, but not the state. So the choice is there is to how much effectiveness do we want, and what are the costs of that effectiveness?
Well, thank you very much for that. And that brings us to the close of tonight's discussion. I want to thank our panelists, my colleagues from the Dixon Poon School of Law, Perry Keller and Roger Brownsword. I'd like to thank everybody who participated today in the Alumni Office for arranging this. So Good evening, everybody, and we hope to see you at another session soon. Thank you very much.